Hello, my name is Seren Adams. I am founding attorney at Adams Law Office. For today's topic, we're actually going to be talking about whether a will is enough. And short answer is no, a will is not enough. First of all, only property in your individual name can pass through your will to your beneficiaries, so the people that you've named in your will to receive your assets. So for example, if you own something jointly with somebody and you pass away first, that property actually passes to the person you're a joint owner with through their estate plan after you've passed away. So that will that you've prepared saying who you want to receive that asset, if it's owned jointly, it's not going to the person that you've named if you pass away first. So that's one of the big problems with having just a will in your estate plan. It doesn't account for that scenario. And that also means that if that joint owner has a judgment or a tax debt or things like that, it can also potentially attach to that joint owned property. Like if you have your child owning your home with you, that can be a pretty dangerous scenario if they have creditors and so forth. Also, if you have beneficiary designations, those are also assets that are going to pass completely outside of your will to the beneficiaries that you've named. So that's another reason that you want to make sure that you're not just using a will for your estate plan or just having beneficiary designations on assets like life insurance, retirement accounts, and so forth. If you have minors that are beneficiaries, there's a problem there with them inheriting early, too early for them to manage assets, and then it has to be managed by a guardian of their property, and that may or may not be the person you intended to be able to manage those assets for them. And then they inherit the whole thing at 18 if they are minors at the time that you pass. If the beneficiaries are incapacitated or irresponsible, those are also issue areas because an incapacitated beneficiary, if they're receiving public aid, they can lose that if they receive a lump sum distribution from a beneficiary designation like life insurance. Also, if they are irresponsible, that just means that the asset is going to get mismanaged. So you can take care of all of those scenarios through a trust instead of using a will, because then with a trust, you can designate when minors will receive assets. You can say what most people do is a third at 25, 30, and 35, or you can choose whatever ages, whatever percentages you want. You can require them to use it just for things like educational purposes or require that they meet with a financial advisor before actually getting the inheritance. All sorts of things you can build into a trust plan to designate how they would receive it, not just that they would receive it in a will. And then you can also do things like avoiding probate if you're using a trust plan. That's one of the big benefits of using a trust, and one of the big negatives of just having a will is that that will is going to go through probate, which is going to delay distributions to your beneficiaries, have an administrative burden on them for when they are inheriting, that they have to go through that court process where the court supervises the distribution of the will, and it has to go through probate. It is not avoidable with a will. If that's your only planning tool in your estate plan, and you don't have a trust, then the estate is going through probate. And it's costly, causes a delay, and an administrative burden, and it is public. So those are all of the reasons why a will would not be enough to have in your estate plan. It really is considered a supplemental document for an estate plan if you have a thorough estate plan in place, that it really incorporates a trust and the other documents that you need in your estate plan. So if you'd like more information on topics or information like this, you can sign up to view our detailed estate planning webinar at mylegacylawyer.com, and you can get more information on that webinar there. Be sure to also subscribe and follow us so that you can get notified when we have new videos available. And if you're ready to prepare an estate plan and would like to set up a consultation with one of the attorneys at my firm, you can schedule that legacy planning session online through our website at adamslawoffice.com, or you can call us at 301-805-5892. See you next time.